Good morning, everybody, and welcome to Kites Commercial Property Webinar, February 2026. My name's Adam Himes. I'm a partner in commercial property, and I'll be speaking together with my colleagues, Faye Astin, Emma Nimmo, and Paul Bricknell. So I'm going to hand over first to my colleague, Emma, who will then speak on her chosen subject, which is case law relating to service charge. Thank you.
Thanks, Adam. Good morning, everyone. So I'm going to kick off by running through some recent case law concerning service charges, which highlight important points for landlords in the ongoing management of investments with service charge regimes in place. The first is a case from early this year called Cloisters Business Centre Management Company Limited against Hamid and Vare. This case is key to note for landlords dealing with mixed-use premises. In it, the Court of Appeal determined that the statutory residential service charge regime applies to mixed-use premises. So what does that actually mean in practice? The statutory service charge regime applies to tenants of dwellings. It requires compliance with a number of procedural requirements and includes restrictions on recoverability of service charges. Importantly, failure to comply with the residential service charge regime where it applies can be costly. So some key points to note in relation to the statutory regime are as follows. It allows tenants to challenge the payability of service charges on grounds of reasonableness. It requires formal consultation prior to major works being carried out, and also requires landlords to consult on long-term contracts prior to them being entered into, risking a £250 cap if they don't. Landlords must provide statutory information with service charge demands, without which they are deemed invalid. Landlords are encouraged to involve tenants in the decision-making process. And lastly, tenants have the ability to dispute service charges in the first-tier tribunal. And it's worth noting that service charge challenges in that tribunal, even if successfully defended by landlords, can be time-consuming and expensive. The court in the Cloisters case confirmed that these residential protections apply to mixed-use premises. So for context, in the case, the premises consisted of a suite of rooms in a converted Victorian convent that included a kitchen and a shower room. The lease had a permitted use as offices and ancillary residential use, but in practice, the premises were being used for storage. In order for the statutory regime to apply, premises have to be let or intended to be let as a separate dwelling. The court concluded that primary office use with subordinate residential use would not prevent them from falling within that definition. On that basis, while each case will turn on its own facts, where a lease permits any form of residential use, even if ancillary to a main commercial use, landlords may find themselves subject to the residential statutory service charge regime. The actual use in practice is irrelevant. As long as a unit is capable of residential occupation and intended as such, it qualifies as a dwelling. The decision is important to note for any leases allowing mixed use, whether that's live-work units or commercial units providing ancillary residential use. So landlords should really check their units to identify any permitted mixed use. If mixed use isn't actually required, the lease user provision should be tightened so as to avoid inadvertently triggering the service charge regime. The next case worth noting is Spender and Fit Nominees Limited. This case considered the concept of reasonableness in service charge recovery, and in particular, incurring costs under a long-term contract. This case did actually concern long-term residential leases to which the statutory service charge regime I mentioned earlier applies. So, as discussed, the statutory service charge regime provides that costs are only payable to the extent that they are reasonably incurred. This reference to reasonableness adds a layer to the landlord's decision-making process which is open to challenge and requires landlords to consider the outcome for tenants and whether it's reasonable for the landlord to commit to the liability in the first place. The case specifically focused on whether costs incurred by the landlord under long-term contracts for hire and maintenance of security systems had been reasonably incurred. The main arguments brought by the tenants was that it had become excessively expensive to rent the security equipment rather than purchasing it. And as a result, excuse me, they had been lumbered with a bad deal. The particular problem being that the price of technology had considerably reduced, rendering rental of the systems too high. Whilst this case hasn't actually been finally decided, the court has to date given some useful guidance as to what is meant by costs being reasonably incurred. Importantly, it focused on the fact that it's the decision to incur the costs at the time the decision is made that needs to be reasonable, not the passing on of those costs in later years. So simply because a contract becomes more expensive later or technology becomes better doesn't automatically make the initial cost unreasonable. So in the context of a commercial lease, how the landlord operates the service charge and the extent of the restrictions on the landlord will depend on the agreed drafting of the service charge provisions. As an example, the model form lease service charge is defined as a fair proportion of service charge costs incurred by the landlord in providing the services. Variations on the drafting to this standard position could open the service charge to challenge from tenants and ultimately result in the landlord being fettered from its day-to-day management of the asset. For example, a tenant may propose that service charge is defined as a fair proportion of service charge costs reasonably and properly incurred by the landlord, so aligning it with that statutory service charge regime. In such circumstances, the landlord will be required to examine the potential outcome for tenants, particularly where significant expenditure is intended. In practice, if a service charge provision is drafted in that way, landlords should be able to demonstrate by contemporaneous records, expert advice, why entering into the long-term contract on those particular terms was reasonable. Landlords should be especially careful about long, rigid hire agreements where technology is rapidly evolving. Going forward, it's prudent for landlords to keep tenders, alternative quotes, professional advice, and monitor on an ongoing basis whether a midterm pre-procurement of a service contract is commercially and legally feasible. Ultimately, if a landlord conceded a qualification for reasonableness in service charge, it's best to be avoided so that landlords can freely manage its service charge without challenges presented, such as in the Spender case. So I'll now pass you on to my colleague Faye, who's going to update you about energy performance and EPCs.
Hi everyone. So today I'm going to discuss some recent changes that have been announced by the government in terms of energy performance and EPC certificates. So the government published a partial response to their reforms to the energy performance of buildings regime consultation on the 21st of Jan of this year. The main changes that it has touched on is changes to energy performance certificates, mostly in relation to domestic EPCs. So there is going to be 4 new headline metrics that are going to be on the certificates. So they will replace the existing single cost metric. The new metrics are energy cost, fabric performance, which will consider how well a building stays warm, heating system, which provides data to assist with whether an alternative heating system would be more efficient, and smart meter readiness. So the new headline metrics will provide clearer and more useful information to consumers and will assist the government in addressing issues such as fuel poverty and net zero. They'll also provide owners and occupiers with retrofit recommendations to improve the metrics. So the government has acknowledged concerns raised about the incompatibility of such recommendations if they're not appropriate for particular buildings and building types. And so the government has highlighted that retrofit options are recommendations only, and any building owner should always seek further expert advice to identify if potential recommended measures are more suitable for their buildings. And there will also be an additional 2 metrics as well, which will be energy demand, which is to provide information on energy usage of a building, and also a carbon-based metric, which is to provide a snapshot of the modelled emissions produced by a building. So that's all in relation to domestic EPCs. In terms of non-domestic EPCs, they're not going to change. They're going to maintain the single carbon-based environmental impact rating. And the government has said that will support businesses in the net zero transition, enable them to report on emissions and facilitate ongoing compliance with non-domestic regulations. And the government is also going to have a bit of a crossover period where the current energy efficiency metric will stay to enable comparison between new EPCs and current EPCs. And they're also going to develop some guidance to support the implementation of the new EPCs. So another thing that the partial response to the consultation covers is when EPCs are required. It's previously been suggested that the validity period of an EPC should be reduced, but the government has said that it is going to stay 10 years. So that's for all current and new EPCs. This is on the basis that the government has recognised the potential negative impacts of a shorter validity period, such as higher costs and administrative burden. Although, of course, any owner or occupier can still commission a new EPC before an existing one expires if they wish to do so. And the government has also said that an EPC will be required at the point of marketing the property as opposed to the point of sale or rent. And that's to ensure appropriate information is available to people when making decisions regarding purchasing and renting. So a couple of things that weren't mentioned in this particular partial response to the consultation is something that's been discussed by the government previously, which is the minimum energy efficiency standard and reporting requirements. So previous government targets referred to commercial properties obtaining EPC rating of C by 2027 and EPC rating of B by 2030. That was changed to EPCC by 2030, but these targets have never actually been made official, so they're not yet legal requirements, although it is likely that they will be at some point in the future. But the date could shift again, given that it has done previously. The government's also previously consulted on creating sustainability reporting standards, which any tenants would be required to comply with. And reporting will be based around climate risks and emissions. Neither of these are sort of very helpful when it comes to considering who will legally be required to pay for EPC improvements, though, when a property is tenanted. So this actually depends on the nature of the proposed works, what the lease says in terms of repairing provisions and service charge provisions. So in light of this, if you're negotiating any new leases, it's important to agree at an early stage who will be responsible for commissioning EPCs or energy performance improvement works, so that can be reflected in the lease. You'd need to think about who will pay for any EPC assessment if the existing EPC expires during the term. Who will decide what energy assessor will be used, and then also who is responsible for works that who would be responsible for energy performance improvement works. So whether that would be the tenant or the landlord. If the tenant's repair covenant doesn't extend to those costs, then you need to consider if the landlord can recover them through the service charge. and also that the landlord's rights of entry extend to EPC assessments and energy performance improvement works. And if those points are all clear, then it should hopefully reduce the risk of any dispute arising when those costs are incurred. And if you are negotiating a new lease and need some guidance around these points, then of course we can help. So thanks for listening, everyone. Now I'm going to pass you to my colleague, Paul.
Good morning, I'm Paul Whitmore. I'm head of the private client team at Kites. For those that don't know me, we sort of specialise in wills, trusts, but particularly on tax planning and inheritance tax planning from sort of high net worth individuals. And a large part of our practice is around advising property investors on tax mitigation. There's been much in the news recently about the inheritance tax for farmers, of course, and all the controversy about that being brought in. But in the meantime, I think the tax on property investors has been forgotten because they're in a far worse position than the farmers and the family business owners, and that's what I also want to talk about today. So my headline is that the tax is 90%, and I just want to explain why that might be. So our starting point is inheritance tax is actually 40%. Each individual has an allowance of £325,000, but that is transferable between husband and wife. So effectively, a husband and wife has £650,000. Now, as I say, there's been quite a lot in the news about the trading businesses of farmers having this additional allowance of £2.5 million, with the balance of tax at only 20%. That's okay for property developers who develop and sell on, but property investment is not a trade. And so for property investments, that headline rate remains at 40%. Now, the government is very good. It says, well, you can pay your tax in equal instalments over 10 years, but the interest rate on that unpaid tax is 7.75%. So they're giving with one hand and then taking immediately back with the other bit on the basis that 7.75 is not a commercial rate of interest on debt. So if we take a typical, let's say, a property investment company client with a property investment portfolio of £10 million in a company, equivalent next slide. So the headline rate would be 40% on that, would be a £4 million tax bill. And we're still £5 million short of where I say we are with 90%. But if we look at the next slide, it's not quite that simple. So what I've got here, and apologies for a table full of numbers, but I hope it makes a point. Left-hand column there, instalment, £400,000 a year for 10 years. That's your instalment option. Second column in, that's your interest rate on your unpaid instalments. So by the time you get to 10 years, the £400,000 has accrued £279,000 of additional interest. So the total tax due on that final instalment is £679,000. But here's the big problem. Where's that money coming from? Well, that money typically comes from the company. It needs to come out of the company by way of a dividend. But when we pay the dividend, that dividend is taxed at a further 39% before we get to pay our inheritance tax. So in year one, when we've got no interest on the instalment and it's just 400,000, we have to pay a £666,000 dividend to pay a £400,000 inheritance tax bill, because 266,000 of that is going in income tax before we pay the inheritance tax. And as you see, by the time we get to year 10, £400,000 instalment, £279,000 interest, total tax 679, but the actual dividend required to pay is £1.13 million. Now that equates to nearly 3 times the actual £400,000 instalment. And when you look at the total over 10 years, you look at that bottom right number, just short of my 90%, I'll admit, but £8.99 million of tax on a £10 million company. So you've got a huge problem that, okay, in that 10 years, you'll have been earning rents and property values would have been hopefully going up. but the tax is nearly all of the value of the property on the death of the property investment company on the day of the person's death. Now, we've been pushing clients for years to use companies rather than direct ownership for investment purposes because there are lots of other tax benefits of using a company. But we've got to make sure that when we're looking at this, we're thinking about that ultimate, well, what is the issue when we die? And so with any property investment client who's got an existing portfolio, we talk about a number of things. Go to the next slide, please. The simplest way of avoiding inheritance tax is simply to give shares away in the company and live 7 years. After 7 years, it's out of your estate. But if that company costs nothing to set up and it's grown to £10 million, you're going to have capital gains tax to give shares away. And people don't like paying tax to save tax. And so giving shares away is a barrier. So we then have to look at, well, what are the options? We have a thing called growth shares where we say, okay, value today is 10 million, but we hope it's going to grow to 20 million. Let's create a class of shares that captures all of that growth and we'll give the growth away and just keep the current value. That helps the problem getting worse. It doesn't make it better necessarily, but it stops it getting worse. Variation on a theme, withering shares, is where we have a class of shares that do come down in value over time. And the longer you live, the smaller the inheritance tax bill might be. We can have a family buyout where one generation sets up a new company and buys out the previous generation for an IOU, which is paid over time. That can have even bigger tax benefits for the family. I'm not going to go into detail of it, but that is probably my preferred route for many family property investment companies over the long term. But sometimes actually we have to go back to basics. And just when we're doing a new purchase, if we can get the structure of the new purchase right, so we have the foresight to think about what we're trying to achieve, we can mitigate so much more tax if we get it right in the first place. Sadly, for a lot of property investors, one of the big options for them now is simply to leave the UK. That works more for commercial property investors than for residential property investors, but I've never given so much advice to people who are talking about leaving the UK. Now, I know we've got a mixture of property investors, brokers, finance houses on the call today. I think it's for all of us to think about these things, for whether you're the client themselves or the advisors to the client. It's for all of us to make sure that our clients are getting those structures right. So we're not walking into this huge problem at some point in the future. So if anyone wants to have a chat about this, by all means, get in touch. We can have a chat about individual circumstances. That's me for the day. Thank you very much for your time. I'm going to pass over to Adam, who's going to talk about WhatsApp and using how WhatsApps might be bringing people into property contracts. Thank you.
Thanks very much there to Paul for his very interesting and useful talk about taxation considerations. So, as Paul says, I'm going to talk about WhatsApp, quite a change of tone, perhaps. So my presentation's perhaps a more generic one than some of the previous talks have been, but I'm going to be talking about the construction of contracts in a property context in modern technology and WhatsApp specifically. So. Okay, the background. So we're going to consider what amount to binding contracts between parties, signing formalities in association with those binding contracts, and as I say, WhatsApp as a specific mode of modern communication that I'm sure we're all familiar with, and a very recent case I'm going to specifically mention, which turned on WhatsApp messages. So next slide, please. So the case that I'm going to be looking at, I'm going to call Goodmanson or Mylan versus Goodmanson. It gave rise to the question of whether a property contract had been created, but it was in a context of an insolvency situation and also a matrimonial dispute. So it covered quite a few bases, really. But the question we're looking at here in the context of property is whether a WhatsApp exchange can amount to a property contract. Next slide, please. So In summary, some of the key points in the case of Mylin and Goodmanson, the actual WhatsApp messages, I've abbreviated them here, but one of the parties sent a message saying, I can sign over my share of Southcote Road to you, Southcote Road being a property on Southcote Road in London, the relevant property in that case. And the response came back, with some monthly maintenance, then okay. In other words, the lady, Mylin, was responding to say, in connection with the matrimonial matter, as long as you pay me some monthly maintenance, then okay, I accept you signing over my share of that property. Unfortunately for both parties, bankruptcy followed, and what I mean by that was Mr. Goodmanson was made bankrupt, and that obviously impacted him, but also had an impact on the relationship with his former wife and the question of whether a property contract had arisen. So the matter proceeded ultimately to an appeal, where the judge held, although WhatsApp is a well-established mode of communication, and as I'll touch on a little later, cases have turned on both WhatsApp and emails and faxes back in the day. So there is case law around this, but the problem resides in Section 53(1) of the Law of Property Act, as I'll go into more details shortly. So the 1925 Law of Property Act is a very important piece of legislation in property. It won't go into too many details, but the relevant clauses in that act say that no interest in land can be created or disposed of except by writing signed by the person creating or conveying the same. And a disposition of an equitable interest or trust, etc., must be in writing, signed by the person disposing of the same. So you'll see the word signed appearing both cases there. So the key is that the document must be signed by the person. Next slide, please. So in this instance, the judge held that the exchange of emails didn't amount to a binding contract. He contrasted it with some previous cases, which I won't go into the great details of, but included one example of a construction dispute in JV Homes and Fincham, which is a recent 2025 case where there was demolition work dealt with between parties, and there was a disagreement about the terms of that agreement. One party claimed that the contract was formed by an exchange of WhatsApp messages, whereas the other party said, no, you have to have a proper demolition contract to deal with this. And in that case, in summary, the judge held that the exchange of WhatsApp messages did constitute a concluded contract between the parties. This informal exchange did show that the terms had been agreed. And even though, for example, there was no agreement as to the payment terms, because the Construction Act 1996, which is a very important piece of legislation covering specifically construction contracts, can imply certain terms, including price and payment terms of the price, then that act could fill the gap which may exist in the more loose sort of WhatsApp exchanges in that. Now, in the Goodmanson case, the exchange was of property, potentially, a property contract. And the key point there was that, and it's quite a technical one, I suppose, that unlike an email where your signature might be generated automatically at the footer of a page, and there have been numerous cases which have held generally that having your name on the footer of an email, yours sincerely, regards, etc., that does amount to what's called a signature. The inclusion of your name at the top of a WhatsApp message, in the view of the judge, wasn't sufficient to be signed or a signature. And the judge said that, and I'll quote him, that inclusion of the name is not part of the actual message itself, but merely provides a mechanism to allow the sender of the email or WhatsApp message to be identified. it is properly, therefore, regarded as incidental to the message rather than forming part of the message. And as a consequence, no signature, no signing, no exchange of contracts. And what that meant for the parties in this case was that the bankruptcy took effect, and the share that Mrs. May Lynn was claiming was lost and passed into receivership. She received 50% of the interest in the property, but she was claiming the whole of it on the basis of that exchange that said, 100% of the property to you. And she replied, okay. That didn't have effect. So I think my slides may be slightly jumbled here. So I'm just going to, if we go back one slide, please. Beg your pardon. Go forward a couple of slides to the one we just had there. Sorry about this. Yeah, so I'm just going to have some closing thoughts on this. As I say, it's a very specific case. Each case in law always turns on its own facts, so we shouldn't always read too much into it. But I think it's interesting, firstly, that the courts are willing to consider quite sort of, I suppose, cutting edge technology. WhatsApp's been around for a while, as we all know, but I guess for the slow process that English law moves at, it's a relatively cutting edge technology. So they're willing to consider it. They weren't willing to accept that this WhatsApp exchange amounted to a contract binding on the party. So let's think why. So my closing thoughts are, was it relevant that this property was a high value property in itself and had some emotional significance, being the family home of the parties who were in divorce proceedings, very highly charged. Did the judge perhaps look to set a high bar for establishing that the WhatsApp exchange had created a contract, whereas perhaps in a construction contract, the example I gave, between commercial parties who are more savvy as to how the law works, perhaps more willing to accept that that could give rise to a contract, as I give in the second bullet point there. And more importantly, was the judge right? And I can't really say one way or the other, but when he made the distinction between an email footer, which is automatically generated potentially, there have been cases where automatic email footers have been classed as signatures. Is that really different from a WhatsApp feed, which has a name automatically generated just at the top of the speech bubble when the message comes through, as you'll know? How different is that really? Is it an artificial distinction? Clearly, the judge felt it was different, and that it was not a signature in the case of WhatsApp, where it was on certain email cases. So, whilst you have a single WhatsApp message with a single party's name on it, if you get an exchange with different parties, each speech bubble has an individual name. So you could say that all the parties' names are clearly included in the exchange. So why would that not be a signature? Not for me to say, but could speculate that future cases may be held differently, and another judge may decide that a WhatsApp message exchange can amount to creation of a contract. Just in this case, they didn't. So if we go to the next slide, please. Again, final conclusions. I guess, practically speaking, the takeaways from this case and thinking about the matter generally are to try to avoid the accidental creation of binding contractual terms. So I mentioned the construction case of JV Homes. In that instance, it was held to be a binding contract, so it can happen. Key point, always mark correspondence subject to contract. It's something that's drilled into us lawyers at an early stage. If you want to avoid exchange of correspondence being deemed a contract, stop and think before you send what you might consider to be an informal comment or a throwaway comment, especially in a relationship between the parties where it could be looked at in the future. Parties in a divorce, parties in a construction contract. Stop and think before you hit send, I guess. And the final point, if you're in any doubt, obviously before, during, or after a situation like this, take advice. Kite solicitors have a breadth of expertise that we can help you in matters such as this or any other property or commercial issue that you may need advice on. So that concludes my speech here, and I'd like to thank my co-hosts for their presentations and thank the guests for listening, and look forward to presenting to you again in our next webinar. Thank you.